Hello, my name is Graham Clark. I'm a Canadian home inspector, professional engineer, and expert witness in the fields of construction and home inspection. In this video, what I want to do is go through a case. It's a recent decision in Nova Scotia. It involves a claim, a lawsuit, against a home inspector. And this is not the actual trial. This is not a decision relating to how much anybody is going to be paying out. It's not a finding of fault or anything like that. This is a very specific hearing on a specific point of law, which will be of interest to many home inspectors. And the point is the limit of liability clause enforceable? Now, in some jurisdictions in Canada, limits of liability clauses are not permitted in home inspection contracts. But in some cases, they are. And where they are, courts and lawyers and all sorts of people have had discussions about whether or not these things apply, whether they can be enforced. And in fact, judges and courts, generally speaking, don't like limits of liability clauses, and they look for excuses not to enforce them. And there have been a number of mixed decisions. There's usually something to learn from these decisions. And in this case, I think this is a great example of a learning point, something that we can apply to our own businesses. So I'm going to go through a decision. This is a case known as Smith versus Asaff. And I'm going to give you a link in the description where you can actually download this decision and read it for yourself. But I'm going to have it up on the screen. Now, it is a 28-page long decision. I'm not going to go through all of the points. That would take far too long. Nobody would have time for that. But there are a number of elements here that reference other earlier cases, other precedent-setting cases in Canadian law. And I'm going to deal with those as separate videos in the future. So I'm going to skip over a lot of that stuff, and I want to get right to the meat of this matter. Can a limit of liability clause be enforced? All right, well, let's look at it. And here we have the decision, and you can see that we've got, again, it's a Supreme Court of Nova Scotia decision. We've got information about the plaintiff and the defendant here. Michael Smith is the plaintiff. He's the buyer of the house, so he's bought a house, and he is claiming that there were deficiencies, that the home inspector was negligent in some way. The Asaffs are defendants. Well, they were defendants. They've actually settled. They're not involved anymore. And T.E. Gordon Home Inspections, Inc. That's the home inspection company. So they are now the only defendant, and they are the ones who have applied to court to find out whether or not this limit of liability clause is going to be enforced. And I think that's a smart thing to do. Because rather than going through a 15-day trial, that could be a six-figure trial, over $100,000 in legal fees is entirely possible. Why don't we have a hearing just to decide whether or not the limit of liability clause is going to be enforced? We're just going to separate out that question of law. And if it is determined by this court in this decision that the limit of liability clause does apply, it is enforceable, and in this case, it would limit the liability, it would limit the payout of the inspector to $425. Well, if that's the decision of this court, really there's no need for a trial. If I was that home inspector, I would say, well, that's my maximum liability. I'd pull out my wallet and I'd go, there you go, you've got the maximum you can get out of me. So I think this is a very smart move, and let's see where this goes. This is a recent decision. January 21st, 2021 is when it came out, although it was actually heard on November 30th of last year, presumably by Zoom or something like that. Again, I'm going to skip past a lot of the detail here. I'm going to get to the most important points. Under facts, in February 2009, Mr. Smith and his wife were in the market for a new home. On February 26, 2009, he met Terry Gordon, a home inspector working for TEG, T.E. Gordon Home Inspections, at a property they were considering in Dartmouth. Mr. Gordon had been recommended by Mr. Smith's realtor. There is no dispute that Mr. Gordon presented Mr. Smith with an inspection agreement and that Mr. Smith signed it. That's great. The agreement is a one-page document containing 8 paragraphs. And I do want to point out before I go any further that Terry Gordon, the home inspector involved in this case, is a very experienced home inspector and is somebody who I have a lot of respect for, and I have known him for many years. It's unfortunate that he is having to go through this process, but in no way do I mean this as a commentary on Terry's performance as a home inspector. I hold him in very high regard. But there are some things that we can learn here. Anyway, in terms of these facts, clearly an inspection agreement has been signed. It's a one-page document. I think that's great. Very often if we have multi-page inspection agreements, 2, 3, 4, 5, I've seen really long inspection agreements. Courts sometimes don't like that because it allows people to, well, hide stuff in the fine print. If it's a very simple document, which this one seems to be, 8 paragraphs on one page, I think that's pretty good for a layperson's understanding. Paragraph 1 set out the parameters of the inspection, but paragraph 4 is what I want to talk about, and here's the limit of liability clause, and this is what we're going to learn something from. It is agreed that T.E. Gordon Home Inspections, Inc. employees or agents assume no liability or responsibility for the cost of repairing or replacing any reported or unreported defects or deficiencies, either current or arising in the future, or for any property damage, consequential damage, or bodily injury of any nature. T.E. Gordon Home Inspections, Inc. liability shall be limited to a sum equal to the amount of the fee paid for the inspection. And again, that was $425 plus tax. The buyer and the home inspector were cross-examined. The home inspector indicated, my normal protocol for home inspections is to provide the client with the inspection agreement upon my arrival at the property. I then explain the home inspection process and agreement and ask the client to fill in their information and to sign it. Upon arriving for the home inspection at the property in February 2009, I am reasonably certain I followed my normal protocol. Mr. Smith signed the home inspection agreement. I conducted the inspection and prepared a home inspection report. Well, a couple of things in here is certainly, I mean, this is done in, 2020? The inspection was 2009. Is it realistic to expect that the home inspector would specifically recall the details of an inspection he did 10 years before? No. And courts understand that. But if you can demonstrate or affirm that you have a process that you use all the time, every time, that it's your normal protocol, generally speaking, unless there's evidence to the contrary, that's going to be good enough for most judges. So I think this is good. Very important too. The very important point here, and the buyer, Mr. Smith, agrees to it later on here, that Mr. Gordon gave the inspection agreement to him before beginning the inspection. It wasn't signed after. It was the first thing done. And I think that's great. Mr. Gordon agreed on cross-examination. He did not recall the conversation and couldn't say that he followed his normal protocol that day. Really, why would he? And courts understand that. There is no suggestion in his affidavit or in cross-examination that he had drawn Mr. Smith's attention to the exclusion clause or to the purported limit of liability for negligence. So he didn't specifically point out the limit of liability. This is what is being alleged. So we gave him a contract. Read it, sign it. This is my standard contract. You have to sign it before I begin. Words to that effect. That's what Mr. Smith remembers happening. Now, Mr. Gordon is, of course, an experienced home inspector, and the court recognizes that he knows about home inspection. He knows what's included. He knows what's excluded, and the buyer is a layperson. In fact, Mr. Smith is stating he had no formal training or education other than a BA from St. Francis Xavier University, and that most notably he was currently and was at all times relevant hereto employed as an actor. Most notably, I play the character Bubbles on the television show The Trailer Park Boys. Yes, This is bubbles. I'm not entirely sure how relevant that is, other than the fact that they're trying to demonstrate that this plaintiff, he doesn't know much about home inspection. He doesn't know much about contracts. He's an unsophisticated person with respect to contracts and home inspection. And therefore, the onus is on the home inspector to make sure that the client understands all the various terms. And Mr. Smith, he outlines the sequence of events. Mr. Gordon attended at the property. We met. We introduced ourselves. He gave me the inspection agreement. Mr. Gordon stated before he commenced I would have to sign it, and stated it was a standard form. And in a bunch of paragraphs here, he didn't encourage me to read it. He didn't read it to me. He didn't explain it to me. He didn't summarize it to me. He didn't direct my attention to this. Basically saying, well, you didn't say there was anything interesting in here. You just said I had to sign it. So I just signed it. And he very specifically says, look, he did not say there was a limit of liability in here. And he really should have, which comes up later, although it's not specifically addressed in this decision, but we'll talk about why. Mr. Gordon stood beside me and waited for me to sign the inspection agreement. With him waiting beside me, I reviewed the contents of the inspection agreement, and I thought I generally understood it, and I signed it. I gave it back to Mr. Gordon, and then he started the inspection. Well, he either read it and thought he understood it, or he didn't. But he seems to have understood it. However, he says, at the time I reviewed and signed the inspection agreement, it was not my understanding that if TEG was negligent in performing the inspection or was negligent in preparing the report, there would be limitations on my ability to pursue a claim against it. Nor did I understand that if TEG was negligent, the damages that I could recover would be limited to the amount paid for the inspection and the report. I did not understand that if he was negligent, that I would be limited in any way. He's basically saying the same thing over and over again. I didn't know this until I got the home inspector's statement of defense in the lawsuit. 42 is interesting. Had I understood on the date that I signed the inspection agreements that the inspection agreements limited liability for negligence and or limited the damages for negligence to the fee paid, I likely would not have signed it. I would not have retained TEG for the purpose of conducting the inspection and preparing the inspection report, and I would have explored other options. This is in part because I am admittedly a layperson in the fields of construction and real estate. This was a significant financial purchase for me, and I was highly reliant on the inspection being performed competently and an accurate inspection report being submitted to me. So he's saying, look, if I had known that this was going to be limited for negligence, I would have walked away. I would have found myself another home inspector. I would have done something different. Maybe I wouldn't have even bought this house, whatever his other options were. Now, this is something that would be tough to prove one way or another, but this is what he's saying. His rationale doesn't quite make sense, because he is saying, I was highly reliant on the inspection being performed competently and an accurate inspection report being submitted to me. There is no correlation between the competency of an inspector and the accuracy of their inspection report and whether their liability is limited or not. Like, there really is no correlation between those two. So it doesn't make sense. Anyway, that's what he's saying. However, in cross-examination, Mr. Smith agreed that before hiring TEG, he had dealt with home inspectors before. It doesn't come up in here, and I wonder if it was even asked whether or not those other inspection contracts that he signed had limited liability clauses. I would imagine that would have been a question to ask, but it doesn't come up in the decisions. And once again, we're going to skip over a bunch of things. We get down to Turcon, and this is on what this case hinges. Turcon is a pretty precedent-setting decision in Canadian law that talks about exclusion clauses. And what it says is that the present state of the law is that a series of inquiries have to be addressed when a plaintiff seeks to escape the effect of an exclusion clause or other contractual terms to which it agreed. So in this case, Mr. Smith signed an agreement. He wants to get out of it, and so you have to go through a bunch of steps. The first issue is whether, as a matter of interpretation, the exclusion clause even applies to the circumstances. This will depend on the court's assessments of the intention of the parties as expressed in the contract. And if the exclusion clause does not apply, there is no need to proceed further. The second test is one of conscionability. If the clause is unconscionable, if there is unfair bargaining power, then the clause may not apply. That is not decided in this case. And the third issue is whether or not there is a matter of public policy. If there is something more important to society than the enforcement of contracts, then the contract may not be enforced. Again, something that's not decided in this particular decision. So the real important issue is whether, as a matter of interpretation, the exclusion clause even applies. So let's see. One issue is that Mr. Smith says, this is the plaintiff, says that under the first branch of the Turcon analysis, there's a sub-issue, which is often brought up, that says for the exclusion clause to apply, it has to be expressly brought to the attention of the person signing the contract. Now, this issue is dealt with, but not dealt with in this particular decision. So I don't want to get too much into this, except I will say that if you want greater enforceability of limitation of liability clauses, you had better bring them to the attention of the client. It's really always the better thing to do. Is it absolutely required? No. But is it always better if you do? Yes, if you ever get to court. In addition to the lack of notice, Mr. Smith also says the exclusion clause does not have effect because of the inadequacy of the language itself. He submits that while the clause does limit liability and does limit damages in certain classes of circumstances, the language does not bring negligence or negligent misrepresentation within said classes of circumstances. And he says there's case law that says you have to strictly construe limitation of liability clauses against the drafter in the event of ambiguity. And this is a principle known as contra proferentum. And it's not just limited liability clauses, it's any contract. So if we have two parties, party A and party B, they're going to sign a contract. Party A creates the contract, party B signs the contract. If there's any ambiguity, if there's any uncertainty in the wording of the contract, you get to interpret it against party A, the people who drafted the contract. Or in other words, party B, the ones who didn't write it, they just signed it, party B gets to choose the interpretation. And that's a pretty established concept. Now let's look at this clause again. The limitation clause said, it is agreed that T.E. Gordon Home Inspections, Inc. employees or agents assume no liability or responsibility for the cost of repairing or replacing any reported or unreported defects or deficiencies, either current or arising in the future, or for any property damage, consequential damage, or bodily injury of any nature. T.E. Gordon Home Inspections, Inc. liability shall be limited to a sum equal to the amounts of the fee paid for the inspection. I want to note, you don't see the word negligence in there anywhere. Moving down a little further, Turcon, I'm not going to talk too much about Turcon. We've dealt with contra proferendum, but basically any ambiguity, well, in this case, the plaintiff gets to choose the interpretation. Now, TEG's position on this is that this clause, the thing that I just read, it applies to the claim because the lawsuit is against TEG for failing to observe and report damage, deficiencies, and anomalies. So TEG is saying it does apply. No duty to notify, again, we can skip over that. I'm going to briefly mention it again at the end. So does the exclusion clause apply? Here's what the judge says. There are two problems with this clause as an alleged shield against a negligence claim. First, and most importantly, there is no indication that the unreported defects or deficiencies or property damage, consequential damage, or bodily injury to which the clause refers would be caused by the defendant's negligence or by the defendant's fault in any other form, such as recklessness or fraud. On a generous reading, the clause is ambiguous and must be read against the drafter in accordance with contra proferentum. Did they mention negligence? No. Therefore, according to the judge, negligence is not included. Maybe it's only damage as the result of recklessness. Maybe it's damage that might be as the result of fraud. Maybe it's damage as the result of negligence, but maybe isn't good enough. It's ambiguous. Doesn't say negligence. Negligence not included. Second, and more marginally, so this is a less important point, it seems absurdly generous to construe the words T.E. Gordon Home Inspections Inc. employees or agents in the first sentence to include the defendant company. At best, this ungrammatical language only extends to TEG's employees or agents. The second sentence, also ungrammatical, refers specifically to TEG itself. This creates further ambiguity. Let's just have a look at that once again. Let's get up to the right point here. It is agreed that T.E. Gordon Home Inspections Inc. employees or agents assume no liability. All right. Now, I suspect what that was supposed to say would be something like T.E. Gordon Home Inspections Inc. and or its employees or agents. But it doesn't say that. It says this, and could I interpret that to mean only it's that company's employees or agents? Sure, I could interpret it to say that. And guess what? The plaintiff gets to choose the interpretation. Does that include the company? It does not. It's the company that's being sued, therefore the company has no protection. And the last sentence was mentioned, T.E. Gordon Home Inspections liability shall be limited to a sum equal to the amount of the fee paid for the inspection. Well, that's talking about the company. So again, there's some ambiguity here. Are the limits of liability applicable to the employees, the agents, the company? It's ambiguous. Again, skipping down past, this is a bunch of case law, and as I mentioned, I'll be going through some of these cases in separate videos, but this will just take too long. So the conclusion on the first issue of Turcon, does this exclusion clause apply to the matter at hand? As the court said in Brown John, one of the cases we'll talk about in the future, the average consumer of home inspection services would be very surprised to be told in clear and understandable language that the inspector can be incompetent or reckless or incompetent and reckless and express any opinion he likes regarding major structural aspects of the house and have no responsibility to the client beyond the fee. Nice. Nevertheless, the court went on to say such a result is achievable with clear language. That is also the case here. However, the provision before the court does not achieve the result desired by TEG. At best, the provision is ambiguous and should be construed narrowly against the drafter, against TEG, the home inspector, as the majority did in Turcon. It does not relieve TEG of liability for negligence. Why? Primarily because it doesn't say negligence. The unconscionability is not dealt with in this. It's not really an issue, and public interest is not an issue in this particular case. And the conclusion is, the question posed by TEG is, does the inspection agreement govern damages such that any damages awarded against T.E. Gordon can be no higher than the fee paid for the home inspection? The answer is no. Based on the language of the inspection agreement, under the first Turcon issue, I agree with the plaintiff and disagree with the defendant in concluding the exclusion clause does not apply. And so it's off to court we go. Now at court, there's going to be a trial, unless there's a settlement ahead of time, and it's going to determine the issues of negligence and a whole host of other things. But now we know that in this particular case anyway, the clause is not going to be enforced. What does this tell me? Well, it tells me that exclusion clauses, if properly drafted, and if people have proper notice of them, they can be enforced, and they will be enforced. They will be enforced if they are in clear and understandable language. They can't be ambiguous. And you have to make sure that the clause includes all the circumstances. If you want to be not liable for negligence, you have to say, we are not liable for negligence, or our liability for negligence is limited to whatever it is, the fee paid. So that's what this tells me, that limited liability clauses, where the law permits, are enforceable. But to do so, you have to make sure they're clear, and don't make sure they're clear to you. They have to be clear to a layperson. They have to be clear to somebody who is unsophisticated. And really make sure that your lawyer has reviewed your contract and make sure that it covers everything you want to be covered for, and that it is understandable, that it's going to be enforceable. Plain English, deals with the situation. This is for negligence. Maybe you want to include recklessness or fraud. I don't know. I'm not here to give you legal advice, just practical advice. What are some of the other lessons here? Does it make sense to point out limits of liability to your clients before they sign the contract? Yes, it does. Is it an absolute? Well, this case didn't really settle that. It did raise the issue. But I think you would agree that pointing it out to a client and saying something like, hey, this, by the way, means you can't sue me, or this means my liability is limited, or this means you can't sue me for negligence, or whatever the words are. Maybe you point it out to them ahead of time. Is that always going to be better than just giving them a contract and saying, read it, sign it, or just read it? Yes, it would. So if you have a limited liability in your contract, my advice to you, make sure it's properly worded, make sure it's clear, make sure it says negligence, because that's what home inspectors get sued for. Alleged negligence, typically negligent misrepresentation. And make sure that it's pointed out ahead of time, even specifically. Now that's easy to do when you're standing there at the inspection. You're showing your client the inspection agreement. You say, I want you to read and sign this. Here's a couple of important things that you should take note of. This paragraph right here, that limits our liability to the fee. I'm going to put a star right beside that. I'd like you to initial that you specifically have understood that particular aspect. You know what? Great. Maybe even better, getting your contract out to people ahead of time, making sure they've got a good opportunity to read it. And make sure that if you're emailing it, you let them know, hey, there's a clause in here, number 4, the bottom clause, the top clause, whatever it happens to be, that limits our liability for negligence. I just want to make sure you read and understand that very carefully. So there are some lessons here. I hope you agree. If you have any other comments about this case, feel free to leave them in the comments. And there may be some things in here that we come back to in other cases, because there are other issues here with respect to timing of the inspection agreement. In this case, I think the home inspector got it right, but it could have even been better if, again, for example, we had given the client a couple of days to review the contract. That's better. It makes sure that the bargaining power is a little more equal. We're going to talk about that in a future video. Anyway, I hope you learned something. Hope you found it valuable. And feel free to leave any comments down below. And we'll see you in our next video.